Hello viewers, we are here today to discuss another topic of Economics and Law Part 1. I am Dr. Divyansha Kumar, Assistant Professor of Management, Amity University, Punjab. The chapter of our discussion today is Philosophy of Law and Economics. Now there are two primary ways in which law and economics or the economic analysis of law differ from other types of legal analysis. First, efficiency is the main emphasis of theoretical investigation. In simple terms, granting a right to the party most prepared to pay for it is considered an efficient legal system. Researchers in law and economics support both ideas of legal efficiency, which are based on two different theories. The normative theory of legal efficiency holds that law should be efficient, whereas the positive theory of legal efficiency contends that common law or judge-made law, which makes up the majority of the law in England and its former colonies, including the United States, is efficient. It's critical that two hypotheses continue to be distinct. Most economics accept both these hypotheses. Now, markets are more efficient than courts according to law and economics. The most positive theory states that legal system will compel a transaction into the market whenever it can. In cases like this, the legal system tries to mimic a market by speculating about what the parties would be wanting in the event that markets had been possible. The focus on incentives and how individuals react to them is the second feature of law and economics. For instance, the goal of damage payments under accident tort law is to encourage future aggressors to take effective cost-justified preventive measures in order to prevent causing the accident, rather than to compensate the wounded parties. The fields of law and economics share the premise that people are rational agents who react to incentives. People will refrain from engaging in an activity when the consequence for doing so rise. When measuring these responses to incentives, law and economics are more likely than any other areas of legal analysis to employ empirical or statistical approach. Three tasks that are associated with property and property rights are required by the private legal system. The first duty of property law is to define property rights within the system. The second, the system must permit property transfer, and contract law fulfill this role. Lastly, the system needs to safeguard property rights, which is what criminal and tort law are for. These are the main topics covered in economics and law studies. Scholars of law and economics also employ economic concepts such as game theory to address issues that are solely legal, including the litigation strategy of different parties. Despite the fact that there are characteristics of both law and economics, legal scholars are more interested in them than economics. The history and significance of this topic is that the publication of Problem of Social Cost by Ronald Coase, who would go on to win the Nobel Prize in the year 1960, marks the beginning of modern law and economics. Despite the contributions from Frederick Hayek, Gordon Tullock, Gary Becker's 1968 article on crime, which earned him a Nobel Prize, initiated this field's expansion. The area of law and economics saw significant growth in the year 1972 when Richard Posner, a leading proponent of the positive theory of efficiency, established the Journal of Legal Studies and published the first edition of Economic Analysis of Law. Now, Posner continued to be a distinguished academic and he went on to become a federal judge. A series of seminars and legal courses of economists and economic courses for attorneys, coordinated by Henry Maine and partially supported by the Liberty Fund, played a significant role in the growth of law and economics in the year of 1970s. The field has now firmly established itself with 8 associations, including the American, Canadian, European Law and Economics Association, as well as multiple periodicals. The major economics journal also frequently published articles on law and economics, and the law review articles also use this methodology. Now, most law schools provide courses in both law and economics. Most of the members have economics training. Numerous economic departments also teach courses on this topic. Undergraduates thinking about going to law school would benefit greatly from taking law and economics courses. Numerous consulting business also focus on offering economic knowledge in legal proceedings. Now, let's come to the foundationalist theories on law and economics. The first theory, which is the J.R. Commons theory, J.R. Commons provided one of the most significant and pioneering theories of law and economics. His idea of property gave rise to broad insights about how the economic and legal system have changed over time. He defined a market as the mechanism through which exchanges occur. He maintained that the market could only exist because of the cooperation of two parties and two transactions, that is, the real transaction and its best substitute. Now, this particular context, which was defined by the disparities between parties, was where the price system was working. The distribution of economic power throughout society is linked to this discrepancy. Instead of taking place in the market, the exchanges between legal and economic superiors and inferiors occur inside the economic institutions. Economic power impacted the institution's legal authority, thereby increasing the inequality. Hoffman's theory of legal power and legal rights was closely related to the Commons implementation of the idea of legal power connected to the various social strata. As a result, the idea of management transaction and economic institutes was developed. Now, let's come to the second theory, that is the Ronald Coase theory. The Ronald Coase was in agreement with the J.R. Commons as well. He accepted Commons differentiation between two managerial transactions and bargaining. The former discussed market exchanges and how businesses and governments are examples of economic entities that supersede price processes. Coase claimed that the original rights allocations become meaningless in the zero transaction cost society. However, this hypothesis is not applicable in practical settings. The law generally impacts both the allocation and the transactional expenses. This serves as the foundation for the normative cause theorem, which holds that judges should carefully consider all economic considerations and their ramifications before making any legal decisions. Furthermore, they ought to take them into account in order to reduce transaction costs to the extent that this is feasible without producing any excessive amount of ambiguity regarding the legal position itself. Moving on to the third model, that is the general equilibrium model. Replacing the market with the firm, the general equilibrium model minimizes transaction cost by viewing the firm as an institute with its own hierarchical authority and decision-making ability. Thus, market establishes a framework necessary for the correct operation of the economic system. The certainty of the legal position which marks the boundary of the instrument purpose-oriented legal decision-making process, continues to be one of this framework's most crucial aspects. Upon close examination, causes theory reveals that the economics of law deepens our understanding of the interactions between two value systems and social framework. The market economy, consisting of individual activities and subject to legal regulations and law, perceived as normative system that establishes order and stability for all individual actions. According to Hayek, spontaneous order is defined by free individual action. Nonetheless, the so-called abstract rules of just conduct place restrictions on the freedom of agents. Hayek distinguished between the purpose-oriented regulations that come from the legislative process and the rules of right conduct known as nomos. Nomos consist of rules without a specific goal in mind. Though upholding the cosmos or natural order is the primary goal of nomos as a collection of principles of just conduct. Conversely, the thesis delineates goal-oriented norms, the primary function of which is to allude to the objectives of an organization such as state. Additionally, there are two categories of social order: taxis and cosmos. The state's purpose-driven order is taxis, while cosmos, meaning spontaneous order, typically refers to the great society and its pluralistic approach to ideals and forms of social and individual life. The primary concern addressed by Hayek are the relationships and interaction between these two categories of order and the rules. He ascribes the thesis to public law and the nomos to the regulations of private law. Hayek argues that since there is a genuine risk of public law taking precedence over private law due to the state's inherent propensity to expand and enlarge the scope of public regulation, nomos and thesis should remain distinct from one another. However, this premise is hard to reconcile with the modern legal system structure, where the rules of both public and private law conflict with one another. Now, let's come to the anti-foundationalist theories on law and economics. First is the Lahman theory. Talcott's person's structural functionalism serves as the foundation for the origins of system theory. However, Lahman's support for functionalist structuralism and the notion of law as autopoiesis links to the paradigm shift from foundationalist to anti-foundationalist social systems theory. According to his idea, the law is an autopoietic social subsystem that is operationally closed, self-referential and self-replicating. Another way to think about law is as an institutionally and methodically generalized normative behavioral order. This indicates that the legal system and the subjects of legal norms or legal actors view the law as a type of knowledge regarding various courses of action. Therefore, Lahman does not see any independent relevance in the application of law. This idea holds that its sole purpose is to signal and disseminate information regarding the enforcement or non-enforcement of the law by government mechanisms. In the system theory of law, the legal system is not the sole focus. All subsystems share social communication as a form of inter-systemic contact. The fundamental dynamics of legal communications give rise to an emergent reality, which is law. The creation of laws follows a circular rather than a linear communication process. The economy, which is likewise a closed system, is comparable. Now, moving on to the second theory, that is the Tubner's theory. Tubner argues that while the economy deals with information about utility and non-utility, the law encodes information about legality or illegality. Although both systems are completely independent, there is a chance for intellectual influence during information translation and decoding. One example of this type of process is the sanctioning process, which translates legal information into economic terms. The economic environment interprets the legal sanction as a simple expense. Disseminating this reasoning across the communication systems for law leads to a certain level of economization of the legal system. Tubner cites the Hand formula and the doctrine of efficient breach as instances of this type of procedure. Due to the close nature of both of these markets, communication is the sole means of contact. Economics, law, and the social structure all change simultaneously. Legal procedure, the idea of a legal act, legal rules, and legal doctrines, therefore, constitute the hypercycle that characterizes the law. A new method of regulation known as option policies should replace the conventional command and control strategy to address the co-evolution of law and economy. Such regulation affects the economy as a whole in a more practical manner. The fact that the legal acts have an equal impact on both systems serve as evidence of this. As a result, the regulations ought to be beneficial from both the standpoint of the economic agents and the boundaries of the law. It is an acknowledged and well-known truth that this theory of social systems provides an interdisciplinary understanding of the relationship between economics and law. Now, let's talk about the interdisciplinary paradigm. There is a contradiction between fundamentalist and anti-fundamentalist conception of law and economics. The historical viewpoint has to do with this paradox. In actuality, the issue has a direct relationship to the debate over historical justice under private law. The idea of Aristotelian conception of justice has formed the basis for historical justice. He compared market exchange to commutative justice. Market forces determine the price and exchange value. In cases where voluntary exchange fails, the judge sets the price. He is not the state's representative. Rather, he represents a certain form of distributive, justice-based justice system. Aristotle disapproved of the idea that social life could be based on commercial trade. However, Aristotle did not distinguish between community and society. The Greek polis relied more on friendship and interpersonal relationship rather than trade. Friendship, unlike commercial ties, is motivated by self-interest rather than concerns for others, forming the basis for the distinction between these two kinds of relationships. Because of this, Aristotelian concept of friendship appears to be an act of kindness and altruism, which can be considered irrational or at the very least inexpressible for an economic standpoint. According to Aristotle, there are two basic aspects of law. The law should be viewed as a centralized informational piece that functions as a cognitive resource, upholding expectations for other agents' behavior. Law is a cognitive resource that functions as a form of mechanism that harmonizes social interaction. The legal standards and principles that are taught beforehand tie the law to its essence. The autopoietic theory of law, or the theory of social systems, states that this constitutes the essence of law. Secondly, the law serves as the cornerstone of social order and provides an institutionalized normative system for conflict resolution. Contrary to what the virtual system theory predicts, enforcement is actually vicarious. In actuality, a lot of laws are self-imposing and can even seem like conventions. The law is a special normative system that arises from the ultimate nature of legal sanction. According to Tony Lawson, the modern economic system is one of these deductive systems. The legal system is another type of normative system of axioms, rules, and principles according to its positivistic interpretation. The idea of a legal model and the normative nature of the economic model are similar, but neither systems interfere with the other's normative aspect. Coming to what Karl Marx had to give to this field, Marxism is the philosophy that Karl Marx advanced. He was a philosopher, social critic, economic theorist, and revolutionary thinker of the German descent. Marxism is associated with the principles that Karl Marx developed in his later life writings. He always held the opinion that society is only superstructural, reflecting the ruling class's goals, the social structure's economic foundation, and internal class conflicts. According to Marxist jurisprudential theory, the economic foundation of specific social structures and production methods determines the nature of legal relationships. According to him, the law is a tool of class oppression that primarily serves the ruling class while denying the working class and oppressed classes chances. Because of all of this, people now think that capitalism is an extremely exploitative type of economy. The working class often perceives capitalism as an economic system in which the ruling class oppresses and unfairly benefits them. Marx's conception of the social order and legal system coincided with his knowledge of society and social processes. Marx synthesized and integrated every philosophical idea from Hegel to Aristotle. Marx's sociological understanding of society led him to declare the ideal system should be a communist society freed from all forms of bureaucratic and political hierarchy, based on cooperative production, logical planning, and equitable distribution. He claimed that the idea of public money came from Borges. He thought that the historical task of the proletariat was to free society as a whole. To him, the law appeared to have no independent life and was merely an apparatus of economy. Now, he asserted that a resolution to the struggle between the different social classes would eventually be necessary. The dispute will be resolved through a proletarian revolution. Once this revolution occurs, it will take control of the state and turn the means of production into state property in the first place. According to him, a capitalist society must give way to a communist society, and as such it will be inevitably bear some characteristics of the former. Now let's come to the Karl Renner theories. Karl Renner, a politician from Austria, earned the title Father of the Republic, leading the first German-Austrian administration and the first Austrian Republic in 1919 and 1920. He was also instrumental in the establishment of the current Second Republic, following the defeat of Nazi Germany in the year 1945, serving as its first post-war president, and of course fourth overall. He thought that because the new society performed in the womb of the old, and because this also applied to the law, the socialists and Marxists had failed to comprehend the new society. He asserts that switching from one given order to another happens automatically. He believed that the way we think about property now differs from how Marx understood it. He argued that Karl Marxian idea required reformulation. He argued that property under both capitalism and socialism no longer served as a tool for exploitation, but rather was subject to a number of limitations due to the natural forces of change. For instance, the customers, workers, or tenants. He did, however, add that the power of property is unaffected by the political nature of the state. Now, concluding with the topic, the decline of jurisprudence made it easier for the economic interpretation of the law to permeate legal theory, legal practice, and legal education. The modern jurisprudential idea that pragmatism has assailed provide a shaky foundation for legislation and adjudication, which has put classical legal theory in jeopardy. It requires a deep ontology, reasonable assumption, and a fairly broad view of law and economics. An interdisciplinary approach can prove and put into practice these claims by addressing the challenge of how the market and the law can coexist and function within the intricate networks, exchange patterns, and communication systems of the social reality. Our free exchange policy within the framework of society as a market is founded on ideas such as property protection, contract freedom, and institutions with their hierarchy, power, and shared goals. Indeed, society is in desperate need of a shared theory of law and economics that consider the intricate interrelationships between institutions and the market. A strategy should be passed on the idea that social norms serve two purposes in society. While the law, as an enforceable normative framework, protects the rights and enforces responsibilities physically or traditionally, it also serves as a kind of cognitive resource by setting expectations about the behavior of the other agents. With this, we come to the end of our lecture. I hope you learned something today. Thank you.